Good afternoon, Dennis.
Hello, everybody.
Hello.
Hey. Are we ready?
No, I think that's Teams.
I think we're ready to begin.
Good afternoon, everyone.
Good afternoon.
Good afternoon to the tenants of the District of Columbia and in the DMV.
Hello.
I am Johanna Schreed, the Chief Tenant Advocate, and I'm here to welcome you, and I'm excited that you have joined us this afternoon to hear about some very exciting new information that will hopefully inform you and ensure that you are up to speed on what's happening at the local, federal level as it relates to housing in the District of Columbia. I welcome you today, in as much as this is the 20th year that we are celebrating the anniversary of the Office of the Tenant Advocate. And so we've got a lot going on. The annual report is up and you'll be able to see it both electronically, and if you need copies, we're happy to deliver those to you at your request. We have an exciting program for you today. It will start with a policy discussion, and I want to thank all of the legislative staffs from the various council offices that have agreed to join us, knowing how busy they are during this time of the year. We also will have a presentation from our Education and Outreach branch to keep you up to date on all of the activities that are happening here at the Office of the Tenant Advocate and going forward. And then we open it up to you, the tenants who we are here to serve, for you to tell us what's on your mind. So I look forward to being with you the next couple of hours. Okay, Joel, take it away.
Okay, thank you, Chief Tenant Advocate Freed, and welcome everybody. As most of you know, the council is now finalizing the district's FY27 budget. Upon their return from the summer recess in mid-September, immediately following the budget finalization, only 3 months will remain in council period 26. Affordability, building conditions and inspections, property managers who are making the news, utility fees, TOPA, likely some cleanup of the Rental Act. These are just a smattering of the many critical issues that are facing district renters. For sure, one thing we know, it can't get done, all of them, and tough choices are going to have to be made. So which pending measures should the Housing Committee try to get over the finish line by December? We are fortunate to have with us today key legislative staff representing 3 members of the Housing Committee. They will discuss their boss's priorities and also take your questions and hear about your priorities. Before I introduce the panelists, we'll first turn to Joey, who's going to give us a very brief legislative and budget update. And he promised me he's going to take no more than 5 minutes. Joey.
Absolutely. Hi, everybody. Let's get this PowerPoint up first before I begin.
And can I just say hi to Tom Gregory? I see he's joined us. Hi, Tom.
Hi there. Can you hear me?
Yes, indeed I did.
Okay.
All right, I'll go ahead and begin. Good afternoon, everyone. My name is Joey Trimboli, and I'm a legislative counsel at OTA. Today, I'll be providing a brief legislative update. I'll start with an update on the local and federal budgets for housing for fiscal year 27, and then I'll do a quick overview of key utility billing legislation before the council. First, some highlights from the local budget. Yesterday, the council approved the Local Budget Act for fiscal year 2027. The budget would be effective October 1st following mayoral and congressional review. The council's Committee on Housing was able to find an additional $200,000 for OTA's emergency housing program, bringing the total to $770K. This program temporarily houses tenants in hotels after a fire or other government closure of their rental housing. Some other highlights: the council provided additional funding to subsidize tenant housing costs. This includes $1.7 million for the Housing Authority for security deposit assistance and $28 million for new housing vouchers. The council also provided, as part of a contingency list, that $9 million will go towards extending federal emergency housing vouchers if sufficient revenues are available. For the Housing Production Trust Fund, $62 million was allocated with 15% dedicated to preservation. The council fully restored access to justice funding to $31.8 million. Access to justice provides low and moderate income residents with legal assistance to navigate eviction lawsuits and other housing crises. I'll move now to the federal budget process. On June 3rd, the House Appropriations Committee marked up its FY27 funding legislation for the U.S. Department of Housing and Urban Development, or HUD. The House bill allocates $71.4 billion for HUD, which is an overall 8% cut compared with the current fiscal year. This includes $25.4 billion for tenant-based voucher renewals, a cut of 29% for a total of $2.3 billion for public housing capital needs, such as repairs. And the House bill also cuts fair housing activities by $38 million, or 44%. This is of concern, especially because this funding goes to local governments and organizations across the country to help enforce fair housing laws. One notable amendment to the House bill: HUD had published a proposed rulemaking earlier this year that would have prevented mixed immigration status families from continuing to live together in publicly assisted housing. House Appropriations Committee approved an amendment that would prevent the agency from implementing this rule. As far as next steps, Senate budget negotiations are currently ongoing. The two chambers of Congress will try to arrive at a budget compromise through the reconciliation process. Once both chambers have approved the legislation, it goes to the president for his signature. Moving on from the budget, it's the summer now. Electricity bills are rising as we turn on air conditioning, so we know utility bills are on people's minds. So for the next portion of this update, I'll highlight a few utility billing measures that have either been approved by the council or that are under consideration. First, a bill that the council approved and that is now under mayoral review. This is the Fair Housing Practices Act, introduced by Councilmember Allen, would prohibit a landlord from charging a tenant for common area or vacant utility costs as a separate charge from the monthly rent, would require a landlord to provide an outgoing tenant with a notice of unpaid charges within 45 days after move out. And if the mayor does not veto this bill, it will face a 30-day congressional review period before becoming law. The next few bills are still under council consideration. First, a utility billing transparency measure on which the Committee on Housing and Transportation and Environment recently held hearings, the Transparent Rates and Utility Expenses, or TRUE Amendment Act. This would require a landlord to provide the tenant with a formula the landlord uses to calculate the utility bill, copies of the landlord's utility bills, and contact information for any third-party biller. It would require the landlord to allow the tenant to inspect their submetering equipment for their unit, and require the landlord to obtain a tenant's written agreement before implementing a new utility charge or changing the method of calculating the charges. The OTA drafted many provisions of this bill, and we're very hopeful that the council will approve it to provide tenants with greater transparency around their utility bills. Next are two bills that would each empower tenants to step in where the landlord neglects the water bill and the water service is therefore subject to shutoff. First, the DC Water Billing and Disconnection Modernization Amendment Act of 2025. This establishes a timeline for DC Water to notify the owner and tenants when water service is to be shut off, and to permit a tenant or tenant association to receive the bill in their own name and pay the bill and keep the water moving, keep the water service on where the property is subject to shut off. Next, the Improving Tenant Access to Water Bills Act. This would permit an authorized tenant to request and receive a copy of the water bill, the landlord's water bill, apply for and receive DC water payment plans and other assistance programs, and require the landlord to deduct from the rent any payment that a tenant makes toward the water bill. And lastly, one last utility measure I'll highlight is the Utility Disconnection Protection Act. This would prohibit disconnection of electricity or gas service basically during the hot and cold months from May 15th to September 15th and November 1st through February 29th for protected households. Those protected households would include children under 18, seniors, individuals with disabilities, those who are pregnant or 12 weeks postpartum, and recipients of certain public assistance program benefits. And finally, I'll turn it over to OTA's Legislative Director, Joel Cohn, for a couple of other matters. Thank you all very much.
Nice job. Thank you, Joey. I'm going to add a couple of measures on effective April 16th. A Housing Committee Bill 26-108, the Extreme Heat Eviction Protection Amendment Act, took effect, and that prohibits evictions on days where the temperature is predicted to exceed 95 degrees. Additionally, prospectively, we understand that it's possible. The mayor is going to be introducing what's known as Rental Act 2.0, which is intended to clarify some of the provisions in the Rental Act that was enacted at the end of 2025, and correct some of the more problematic provisions. OTA has made suggestions along those lines, which may come up in the discussion. I'm also going to mention federal legislation because it passed the House yesterday. So the House is joining the Senate in approving the what's known as the 21st Century Renewing Opportunity in the American Dream to Housing Act, or the 21st Century Road Act. So both houses of Congress have passed it. It's headed to the president's desk. I just heard about a wrinkle in that process. Surprise, surprise. But it would, among other things, restrict private equity ownership in the rental housing market, specifically single-family dwellings, and it removes regulatory barriers to the construction of rental housing. So those were two issues that were prominent in the discussion last year over the Rental Act, but were not necessarily fully addressed. With that, so that's another issue that we'll put on the table for our distinguished panelists to discuss if they so choose. And I'm going to now introduce the panelists. They are Kate Conquest and Maurice Cates. Both are legislative assistants to Housing Committee Chairperson Robert White. Kevin DeGood, he's legislative director for Councilmember Matthew Fruman, and Sean Cudahy, who's now the committee director for Councilmember Brianne Nadeau, and up until recently was the deputy committee director for Housing Committee Chairperson Robert White. So does the Housing Committee, Kate and Maurice, do you guys want to start?
Yeah, absolutely. Just with a summary of what we've done and what we plan to do for the rest of the year.
Sure. Whatever
Okay.
you'd like to say, Kate, is great.
Careful. Hi, everyone. I'm Kate Conquest, legislative assistant for Councilmember Robert White, my colleague.
Maurice Cates, legislative assistant.
Some of the highlights that I wanted to share from like this past year, Joey and Joel already touched on which are the Fair Housing Practices Amendment Act, which was about preventing landlords from charging tenants separately for utility charges accrued in common spaces and vacant units. We worked really closely with OTA on that and are excited that it passed the council. And same with the extreme heat eviction protection bill, which was introduced by Councilmember Lewis George, and now prevents evictions on really hot days, which mirrors the existing protections that were already in place for really cold days. We also passed a bill called Powering Local Utility Guidance, or PLUG, which is aimed at speeding up the process for affordable housing developers, especially when it comes to getting utility permits, which are notoriously slow and complex. And so hopefully that we can sort of add a more streamlined process and get more of those units in place quicker. In terms of what's next, we have a lot of ideas, I think, for the fall, but some of the main ones. The first is an eviction mediation program. We've looked at cities like Philly that have programs like this in place. There's a ton of evidence that these are really effective. So this would require like good faith mediation before an eviction can take place. I think, we've heard support for this idea from housing providers and tenants alike. I think devil's in the details in terms of like support for pre or post filing and mandatory or optional and things like that are all things that we will work out. But there's a lot of evidence showing that these have very strong results and hopefully will also alleviate the burden on the courts. So we'll be working on that this summer and plan to introduce it in September. And we'll work really closely with OTA on that as well. We have some other ideas about increasing supply, again, mostly focusing on reducing like administrative burden and permitting reform, regulation reform to make it easier to build and get access to affordable housing. And then another big focus for our boss is building conditions and holding bad actor property managers to account. So we've introduced some bills that already touch on this. Those are already introduced and sitting in other committees that will work toward getting those moving forward, and then also have some other ideas. And Maurice is our lead on that, so I'll let him touch on those ideas.
So hello, everybody. Right now we have 3 bills that are introduced. One of them is scheduled for a hearing in July. We have the Lean Act, and this is an act that gives the Department of Buildings greater special assessment authority. Currently, when they want to place a lien on a property, they have to abate themselves a violation that they've inspected and noticed. With the Lien Act, this allows them to place a lien on a property before they've abated the violation, with the idea that, okay, we are going to do this in the future, and when we do, it's going to cost this much, and we're going to bill you this now. When we talked to DOB, we were going over their fine collection statistics. Currently, they collect about, I don't know, let's say average of 11% through their current NOI process. They found that they receive a 50% return through the lien process. And in our talks, they said that giving them this greater special assessment ability is something that would drastically improve, 1, landlord response, and then 2, collection rates on fines. We have the Clean Act. This doesn't necessarily add any new enforcement mechanisms, but it does clarify and basically brings it to a surface level in the code that NOIs that are distributed by the Department of Buildings are debt that is prohibitory to getting a clean hand certificate. Currently, there's, I suppose, some ambiguity, or maybe there is a political reason as to why some of these debt profiles are not sent or not considered. But we want to make sure that it is spelled out very clearly. If you have adjudicated debt from an NOI issued by the Department of Buildings, then you do not qualify for a clean hand certificate. We also have the Strong Homes Act. That is an act that we did in conjunction with the Attorney General's office. And what it does is it strengthens the receivership process in a number of ways. It increases the list of violations that count towards a building being eligible for receivership. For example, mold at this point in time is not a reason for a building to be in receivership. There are guidelines put in place to speed up the receivership process. Currently, one of the ways that a property owner whose property is under petition to go into receivership, they have the ability to give an abatement plan to the court, and say that this abatement plan is good enough to defer this building being put under receivership. And that's something that's being removed. In order to ward off receivership, you have to have a significant number of funds that are in place to show that you can make a certain amount of abatements. Because it seems as though in the past, landlords would give these plans, property owners would give these plans, and then they would fall through, or they simply would not have the funds to abate them in the first place, and you're kind of, starting back over from square one. We also have another bill in the works called the Mean Act. That is basically tying enforcement to a pattern of behavior. So if a property owner has class 1 or class 2 violations of a certain magnitude over a certain period of time, then they get their housing and lodging license removed. That hasn't been introduced yet, but it is very, very close to being introduced. I've been working very closely with OAH. So we expect to see that sometime before recess. One of the one of the office's priorities has to deal with the amount of money that certain bad actors are able to get from the district, whether that be, loans, grants, contracts, vouchers. And we're also going to try to find an established pattern of behavior thresholds to where you can say, hey, this entity or perhaps this natural person is no longer allowed to receive funds for the district for these particular sets of projects because they have shown a repeated bad pattern of behavior. So that's just a little bit of what we have now and a little bit of what's coming down the pipe later.
Send it back to you, Joel.
Great, thanks so much. That's great. And Kevin DeGood, do you want to go next?
I don't have a whole lot to put in here. I will just say for Councilmember Fruman for the rest of this council period, and I think on into the start of the next period, has a couple of priorities. One is going to be pushing forward and getting to markup on the Rent Stabilization Protection Amendment Act of 2025. This is a bill that would require housing providers to only charge voucher holders the rent stabilized rent if rent stabilization applies in the building. We think that this would help to not only ensure that voucher dollars and LRSP go further and can help more individuals and families, but would also undermine the economic model that has led to constructive evictions from some unscrupulous investors who have come in and bought up rent stabilized building, pushed out non-voucher holders, and then filled them with voucher tenants. I think another big concern for Councilmember Fruman is the rate of economic vacancies. We participated in the Housing Unity series of conversations over the last couple of months, and it became clear from those conversations and others on the sidelines that there are just a whole lot of housing providers in the affordable space that are badly underwater on their properties because of economic vacancies. In fact, many of them are not just underwater on the soft debt financing they've gotten from the district through the HBTF, but on their hard bank debt as well. And I think we're at risk of seeing foreclosures and the loss of affordability covenants in the future. I think as a part of that, he is tracking the overall trend in market rate rents to sort of see what is going on, what is the macro condition, and what are the regulatory barriers that might be feeding into that. We continue to hear from developers that it is hard to raise financing, that it is almost impossible to syndicate DC LIHTC credits. I think it's less the case with the federal LIHTC. Those are still able to move, although I want to say the last couple of developers we talked to said they were getting maybe 70 cents on the dollar for their federal LIHTC. So that's a concern that people aren't looking at the district as a good place to invest. And then this is a little more on the budget side and less on authorization, but I think making sure that we have a long-term plan for the folks who are in the emergency housing vouchers that HUD is likely to discontinue funding. That was included in the contingency list that the council adopted at second reading of the LBA yesterday. It's something we're going to continue to monitor, and I think long-term we're going to need to find a landing place for those folks. And then also just ensuring that there's continued funding for the pool of vouchers, because rising rents and cost pressures in the program mean that we tend to lose vouchers over time, particularly as we don't lease up new households when vouchers turn over. So making sure that there's robust funding for that part of the safety net. And I think that is all from me.
Thanks so much. That was great. And Sean Cudahy.
Hey everybody, thanks Joel. Glad to be here, even though I am sort of Councilmember Nadeau's third string housing policy person. We had my colleague Abby Beauchert, who covered housing policy for Councilmember Nadeau, and will again when she returns from parental leave. And then my colleague David Menny, who couldn't be with us, but has been Councilmember Nadeau's longtime deputy. I have a little bit of familiarity with DC's housing policy from my 3 years at the Housing Committee before joining this office. I'm happy to speak a little bit about Councilmember Nadeau's priorities. In terms of landlord-tenant law per se, that has not been as much, that's not as much of Councilmember Nadeau's priority for the remainder of this council period, I would say. The Common Sense TOPA reform bill that Councilmember Nadeau introduced early last year included a lot of provisions to make the TOPA process more user-friendly for everybody involved. There were a lot of pieces of the coalition's report from a few years ago that Councilmember Nadeau picked up and turned into legislation. And then that bill, Common Sense TOPA Reform, many of its components were integrated into the final version of the Rental Act that the council passed last year. Unfortunately, those pieces were found by the CFO to carry an unfunded cost at the time of passage. And the Public Works Committee, where I now work, made an effort to fund those unfunded pieces. So we're talking about things like an online TOPA database, a system of qualified purchasers who are like reputable investors who the district would say, you know, these tenants, you should feel extra safe working with these housing developers when you want to sell off your TOPA rights and when your building is up for sale. Those pieces, as I said, the Committee on Public Works and Operations attempted to fund the implementation of those pieces through a transfer to the Housing Committee. Chairman Mendelson ended up reversing those investments, and I think not from a policy like opposition perspective, but just based on available funding, we had started our funding allocation in fiscal year 2028 rather than this immediately coming fiscal year. And Chairman Mendelson and his team made a decision across the board to not honor those investments the committees tried to make in our phase of the budget process. So I mentioned this because there are some really good improvements with a lot of consensus to the TOPA process that have already passed the council and been signed by the mayor, but will not go into effect in fiscal year 2027. And then at the end of this calendar year, Councilmember Nadeau, Councilmember Nadeau will definitely lead the council. And if Councilmember Robert White wins the general election for the delegate seat, having just won the primary, he would also not be continuing on the council. So if you believe in those TOPA improvements, we're going to need somebody to step up and argue for their inclusion in the next budget. I'm hopeful that the next mayor will want to fund those things as well, but that's something that I would encourage everybody on this call to push for and to monitor for. And then I think the remainder of Councilmember Nadeau's housing policy priorities are more on the production side, but I'll just quickly run through those. So Councilmember Nadeau introduced the One Front Door bill, I want to say last year. This would respond to a growing consensus that old housing construction standards where a lot of like small multifamily buildings need multiple egresses and to help with fire safety. With modern sprinkler systems, that's no longer really necessary. And so you can get more housing into the same footprint if you just have a single stairway and fewer fire escapes. That similarly passed the council. We similarly attempted to fund it in this year's budget process, but for procedural reasons, not policy opposition, we're unable to do so. So that's another one where if you are looking for ways to build more housing and hopefully ease price pressure on tenants, that's one where I'm hopeful that the district will put funding toward it next year as well. It would push the Department of Buildings to eventually adopt a new housing code that allows for fewer fire escapes to take advantage of modern safety technology and not trade off safety, but just bring the code up to modern standards. Councilmember Nadeau and Councilmember Robert White worked together on a big bill whose name I forget, the DHCD one, the Housing Production Trust Fund Administration one. I don't have the title in front of me, but we'll be eager to see that proceed through the Housing Committee and make better use of trust fund dollars and make the use of trust fund dollars more intelligible, transparent to the public. And then Councilmember Nadeau also put forward, after a lot of collaboration with other council offices, including Councilmember White's team, the Fair Share Housing Targets Act. And I really encourage people to take a look at this one. So as most people on this call probably know, the district is divided into planning areas for purposes of the for purposes of the comprehensive plan. And Mayor Bowser set really positive, ambitious housing production goals, including affordability goals some years ago. The Bowser administration has made great strides in building a lot of housing, not so great on getting that housing equitably distributed geographically across the district. There are some planning areas that have just fallen way, way short of their affordable housing production goals. What the Fair Share Housing Targets bill would do is sort of lock in statute this planning area and affordability target approach that the current administration has already been pursuing, but it would be a statutory framework for it. And the intervention would be that if we continue on this track where some planning areas are way behind their affordability targets, the mayor would not have to wait for this sort of slow, very infrequent planning process. The mayor could go ahead and jumpstart the process on making planning and zoning interventions outside the comp plan process. It would also commission an expert, independent third party who would have the authority to just go ahead and start making recommendations straight at the zoning commission to try and juice housing production at scale in planning areas that have not seen the level of affordability that I think everybody agrees we nominally want, but it's a lot harder to overcome like neighborhood opposition in some areas than others. So again, that's the Fair Share Housing Targets bill, and that's Bill 26-556. If that doesn't pass this year, then hopefully somebody who is on the council next year will take up that charge again. I think that's it from me, Joel.
Wonderful. Thanks so much, Sean and panelists. I neglected to direct the audience to put your questions into the chat. My colleague in Education Outreach, Nicole McEntee, will be taking those questions and then asking the panelists those questions. So while questions, Nicole, do we have questions yet? I'm going to ask the panelists for any follow-up comments that any one of them might have, about something specific or just general comments. But do we have questions lined up yet in the chat?
We do, and just so that everyone's familiar with the structure, we will do questions that simply pertain right now to what was just discussed for our panelists and our policy experts. So simply on the materials we were just talking about, the legislative priorities of the council. But then later at the end of the meeting, we will have time for more of an open discussion about topics that go beyond what was just discussed. So for now, if you have questions on these specific topics, then please, and if you could please mute your mic too while you're not on. But yeah, please put those questions in the chat for now. And I will be reading them. And if you can say who you're addressing them to, that would be helpful as well. So I just go ahead.
Sorry. How much time do we have, Nicole, now for questions?
We have another 20 minutes really. So we're
Okay.
right on. We're good on time. So
let me go ahead and ask the panelists. I do have a one question for Sean about one of his remarks, but does the panel does anybody have any follow-up or something you want to emphasize maybe about one of your council colleagues said, or anything you want to say that you might have forgotten to say? And if not, I'm just going to ask Sean. So in terms of advocates pushing for the funding for the COPA and sort of the quality of the transactions, the provisions, qualifications, qualified purchasers and qualified tenant assistance and all, and then also the portal for complaints about transactions that might be happening. Is the ask specifically for funding in the next budget, or did you have something in mind more immediately?
I think, at this point, there won't be the budget won't be before the council again until like April, March, maybe. And for those who are familiar with the annual budget process, the mayor, under the Home Rule Act, the mayor has the exclusive authority to propose a budget. for each fiscal year. And then once she does, the council has 70 days to approve it. It makes things a lot easier if the mayor just bakes funding for things into her proposal from the beginning. So I would say if you have guesses as to who the next mayor will be, we have some nominees now. If you have guesses as to who the next mayor will be, you could start telling that person what they might want to include in their first budget proposal, which will be due to the council sometime in the spring. Yeah, this TOPA portal, including funding for that in the proposal for the fiscal year 2028 budget, I think would be a big win for tenants.
Okay, great. And Nicole, did you want to go to the chat and pose some questions now? Okay.
Yes, absolutely. So somebody said, just curious as to what provisions in Rental Act 1.0 or the Bowser Act are being looked at as problematic that the possible new 2.0 would address or review.
Is that directed to Kate and
I think,
Maurice, perhaps?
yeah, it doesn't specify. So whoever wants to tackle that one.
Kate, and Maurice, can we put you on the spot on that one?
Sure. Yeah. I mean, I think we've heard from a lot of advocates and tenants that a lot of in terms of the court processes, some of the cases seem to be taking a longer time because in certain circumstances, the judge has to read a lot of information for a tenant or make sure that tenants understand things or give them more instructions. And so while the intent was to make sure that things moved along, unfortunately, in some cases, it seems to be slowing things down. Again, one of the reasons we're looking at things like our eviction mediation program to hopefully mitigate some of that. Some of the other details, I know Joel, you can speak to this better, but some concern about certain like language that's used in TOPA notices. So there might be an opportunity to clarify and tighten up some language in terms of what the housing providers need to share with the tenants about whether their building is exempt or not. There were some other pieces that we had struck from the original bill that might come back, which I can find out more details about. We haven't seen any like actual language for Rental Act 2.0. We've heard from the executive things that they might put in there, but there's still a lot of unknowns. Anything else, Maurice, that you can think of?
Okay. I'll drop that shoot. Thanks, Kate. I think a lot of you know that, OTA has been getting quite a few questions and some complaints and concerns about what's called a notice from the landlord of a change in the applicability of the law. And what that is a requirement in the Rental Act for buildings that have been for the new construction exemption from TOPA, which is to say buildings for which a permanent certificate of occupancy was issued by the government retroactively 15 years ago, and after that 15-year point, and then for 15 years prospectively to the anniversary date when the exemption goes away. The complaint is that, this is not a transaction. It's not a TOPA transaction notice at all. It's just a notice that if there's a transaction transfer of an ownership interest, that building will not be subject, or that transfer will not be subject to TOPA under the new construction exemption. The notices that we've seen, the notice of this change in the law, are very rough and do not accurately convey what the law is, which is that it's a temporary exemption. It's only lasts for 15 years. It doesn't convey that the specific transfer is only exempt if and when there's a notice of transfer issued to the tenants. That gives the tenants the ability to challenge the transfer if they think it's really not a legitimate claim of exemption under that new construction exemption. So we've had very good dialogue with the council, the committee. We've had very good dialogue as well with CASD, which is the Conversion and Sale Division at DHCD, and DHCD itself, and some of the mayor's people. We would like to see that be in any clarification measure that the council, ultimately passes. But that's just to mention one of several sort of snafus or glitches in the Rental Act, system, so to speak. So thanks, Kate, for mentioning that. Nicole, do you want to?
I was going to say the other thing that I was referencing that might come back came to me, which is that originally in the Rental Act 1.0, they had proposed that the project-based vouchers be available for families making up to 50% AMI as opposed to the current threshold of 30%. We struck that at the time out of concern that all of the vouchers would then go to households that have, a slightly higher income and inadvertently push out the ones with lower. And that might be proposed again. We don't know for sure, but I think we will likely see that again, and we can reevaluate at the time and make sure that we are protecting the households that need it the most.
Got it. And I'll take the opportunity to say to our tenant stakeholders or landlords as well, if there's a problem that you see going back to the Rental Act, possible 2.0 legislation, if you see a problem that you want to call to the Chief Tenant Advocate's attention, we more than welcome that. It's really important that we get the specific facts on the ground about what's problematic and what needs to be fixed. So, Nicole, do you want to ask another question?
Yeah, absolutely. I see there was a question in the chat about, as climate change has made things warmer quicker, right? And very cold in the winter. How is DC legislation going to react to that? And I see that Kevin already answered that really promptly. Thank you, Kevin. And you mentioned the COOLS Act. Could you just expand for those who are unfamiliar, just a quick, what is COOLS Act and what's the intent here?
Yeah, I'm doing this off the top of my head, but it basically takes the existing dates at each end of the season and pushes them back 15 days. So you would have to turn the heat off and start the process to switch over to air conditioning 15 days sooner in the spring, and then you would not. You would push 15 days further into the fall before you had to turn off the AC and change back over to heat. And this is for, I believe, buildings that are what's known as two pipe, so where you just have one set of radiator pipes doing kind of dual duty, is my understanding. But don't take my word on that. Use the link and look at the bill.
What's the bill number, Kevin?
250279.
You mean 26, I think?
Or maybe did I stick?
Joey put the reintroduced version in the chat as well.
Oh, sorry. I pulled up the wrong.
It's 26-285.
285. Thank you. Wonderful. Thanks. Thank you, Kevin. That's great. And Nicole, you're the timekeeper here, so you tell me if you have time for another question.
Yeah, I see there's one more question in here. And if anyone has any last minute questions, now is the time to throw them in the chat before we move on to the next topic. But if not, then I guess this would be the last one, which is how does the city let this happen? Essentially, it's the 2-month-long elevator outage has DC seniors feeling stuck at home. I think it's a question generally that goes to, when there are things like elevator outages, especially when they impact seniors or people with disabilities, what can we do? What are our options?
Yeah, so that's a bit of a difficult question without the Department of Buildings here, because so under current law, there's only has to be one elevator that's working in a building, no matter how many elevators are present. What we've thought about is maybe making it so that a certain percentage of elevators in a building have to be operational, and perhaps with this increased number, you won't have landlords who let 99 out of 100 go derelict, and then once that 100th one goes, you're left with 0. So if you're at a situation where 50 out of those hundreds have to be operational at all times, perhaps that will give a little more cushion insofar as time in repair is concerned. But, with the question of, the city having the authority to go in and abate certain violations, I don't believe that an elevator outage would classify as an emergency and life-threatening situation that DOB would abate. I can't say that for certain, but we are looking into some elevator-specific legislation once we reach out to DOB and get some language on paper and start having back and forth about that particular issue, that it would bring more clarity.
Nicole, I can ask a question if you want, or do you want to?
Go for it.
So part two of this meeting is going to be education and outreach. I don't know if that was announced or not, but you have hopefully you have the agenda. But I will go ahead and I think this is probably for Maurice, and this goes to the very good legislation that you're spearheading. We have a problem with building conditions, and it's really been a very, very strong focus for Chairperson Robert White, and the OTA really appreciates that sort of singular lens being put on that issue. We also have a problem with property managers who are making some eye-popping news. It seems to me more and more, and there seems to be sort of part and parcel of maybe collective ownership entities. I'm going to spare Kate and not go into the private equity issue, but I will say that property managers do seem to be part and parcel of the problem. I think the legislation that you've spoken to, Clean and Mean Act, goes mainly, does not extend to property managers. And my question for you would be, would you encourage advocacy along those lines? Do you see that as problematic? Do you think it's something that should be put on the table for discussion? But how do you view the property manager angle on the issues that you're addressing?
Yeah, so property manager accountability is on our fall agenda. The issue here is right now, all disputes between a property manager and an owner are handled between the property manager and an owner. If an owner say, they hire a property manager and they're not doing a good job, you fire them and get a new one. And that's really what the recourse is. When a property manager fails to abate a violation, it's not the property manager who gets fined, it's the owner who gets fined. And that's just the standard procedure of how DC operates and how the law treats the relationship between the property and the property owner and the property manager. What we're thinking about is creating a mechanism for when a repeatedly derelict property manager is behaving in a manner that actually puts tenants' health at risk. How do we levy some sort of penalty to them? At what point and where is the threshold for where the owner has done everything right, the owner has provided a certain amount of money for abatements to happen, but that property manager simply has not done it? We would currently say, fire the property manager, get a better one. But sometimes you have property managers who are acting as de facto owners, essentially, or say that they're coming in with promises to do X, Y, and Z, so long as they have, a certain number of money coming from either rent collections or maybe, contracts from the city to perform these abatements. But then once they get that money, or once they get into a position to do these certain abatements, they just kind of take it and run. So we do 100% believe that property managers should be folded into this accountability network. And we would encourage advocacy along those lines.
Okay, great. I'll mention that our chief tenant advocate, this is something we'll continue to discuss, of course. Our chief tenant advocate has encouraged her policy team to explore the sort of standards by which property managers are licensed to do business, and a license is required to be a property manager if you're not managing your own property. And we, Joey and I, have looked into standards in other jurisdictions and sort of national guidelines, there are sort of what we see as gaping holes in the standards that govern licensing of property managers in the district. And namely, they seem to generally go towards obligations of the property manager to their boss, the owner, and don't say anything about obligations to the tenants and compliance with district law. So that's something that we think the council, could and should, look into, consider, and ultimately fill that gap. So, but again, to be continued on that one.
Yeah, I'm sure that Joel, you and I will have some extensive conversations in the coming months.
Yes, I'll look forward. Absolutely. Nicole, do you have anything, or do you want to move on to the E&O portion?
Yeah, let's move on to the next portion. So I'm going to thank you so much for our presenters, first of all, for coming and speaking. I think tenants get a lot out of that, and they like to hear about, what's coming up in the hopper. So thank you for that valuable information. Go ahead.
Thank you, everybody. No, just want to thank everybody. It was great. And let me also say that Joey and I had reached out to a pretty big collection of community partners, advocates, and tenant attorneys throughout the district to sort of inform this discussion. So this is tip of the iceberg. There's a lot to talk about, what to prioritize and how to go about that in the fall. But this was a super, super good overview and presentation. So thanks to the panelists. Much appreciated.
I just want to say one more thing to the individual Mike R. So what constitutes an emergency? Let's say there are, class 1 or class 2 violations. So there are class 1 violations will count as NOIEs, which are notices of infraction emergency. And then you have certain, NOI or certain class 2 violations that would also count as NOIEs. And it is through this class 1 and class 2 violation framework that's written out that DOB determines whether something constitutes an emergency. So the moral question, I would 100% do agree that an individual who is elderly, living on the 10th, 11th, 12th floor and doesn't have access to an elevator, yes, that's an emergency. How it's currently written, that's not something that constitutes an emergency. Is that something that can be changed? Absolutely.
Thanks. Yep.
I think we have to go at 2 o'clock, so I just want to say thank you so much for inviting us, and we love working with OTA and happy to come anytime. And we will be hitting up Joel and Joey for a lot of our legislative priorities for the fall, so we're looking forward to that. And thank you all for coming.
Thank you, Kate. Thank you, Bruce. Thanks for coming.
Thank you, panelists. So I will share our agenda one more time, just to keep everybody on track. So next, we're going to move on to our announcements from Education and Outreach. And then after we make our announcements about some exciting things coming up, we're going to have an open forum for tenants to talk. So, we will have that at the end where you can either put your questions in the chat or raise your hand and I'll call on people. But I am going to, keep a pretty strict mute policy when you're not speaking so that we can make sure that people don't get talked over. And we would love to hear about what is going on in the tenant community. And we'll have some time at the end, hopefully about 30 minutes or so, maybe 45 minutes or so, before we end at 3. So with that said, I'm
Nicole, can I,
yes,
sorry,
go ahead.
sorry, Nicole. I know my time is up. I should be out of here. But should we encourage, I just want to be clear for our, first half of the program panelists, should they be encouraged to stay because questions will go to them as well?
Absolutely. Yes. We would love for you to stay. I'm sure you would love to hear from what tenants have to say is happening in their community. So if you have the ability, hopefully you're not running into another meeting, but if you have the ability to stay, please do so.
Right.
Awesome. Okay. So all of that said, I should introduce myself again. I am Nicole McEntee, and I am part of the Education and Outreach team. And I am going to talk about some updates that we have going on from our team. So I get to talk about the really fun stuff that's like tenant driven and where we celebrate our tenants in our community. So the first thing I want to talk about is we are going to be debuting a quarterly newsletter. So everyone who is on our listserv, and I assume most everybody who got the link here is most likely on our listserv. Everyone on the listserv will be receiving our quarterly updates. But what we're looking for from tenants is we don't want this to just be updates from OTA, right? You know, we want this to be updates about tenants as well. So if you have some event going on in your community, or if you just started a tenant association and you're really proud of it, or if you accomplished something, maybe you negotiated something with the property management at your community. If you have a win that you want to celebrate or pictures of an event, please send them to us. We would love this kind of content for our newsletter, and it would go out to, you know, all of the tenants on our listserv. So we're looking for that kind of content, pictures, you know, maybe a paragraph or a couple of sentences about, you know, what event you had or what win you could celebrate, all of that kind of material. We would love to highlight you in our newsletter. So please send that our way. I'm going to drop my email in the chat. It's nicole.mcentee@dc.gov. Please send us that type of content continuously, right? So we're doing this newsletter quarterly. So we hope to continue to have that content year round so that we can celebrate our tenants, you know, because that's what this is all about. It's not about us, it's about you all. Now, all of that said, we're very excited, speaking of it being about our tenants, to celebrate our tenant summit this year. So I'm going to pull up on my screen here our tenant summit information. So this is first of all our annual report, which we're really excited to show. We have both a hard copy and a digital copy. So it is available on our website and at this link, which I will drop in the chat. So if you'd like to look through the digital copy, please send it to anyone who's interested in seeing it. We're really excited to share that. We also have our tenant summit coming up, and this is going to be on September 19th. So for those of you who are unfamiliar or have never been to our tenant summit and you're a tenant summit newbie, we have this event every single year. It's about a full day, maybe 3/4 of a day, and it's all about tenants and what you guys want to hear about. So we talk about tenant issues. We talk about what our office has been doing. We have tenant associations talking to each other. So you get to know tenants from around the city. There's workshops and panels. We're really excited about our plenary session because we're celebrating 20 years of the OTA this year. So we're really excited to kind of show what we've done and how we've helped tenants throughout the past 20 years and what we're working on for the next 20 years. So if you haven't already, please sign up, please register for our tenant summit. I will drop the link for this in the chat as well, but this is the basic registration. And on the registration, we're also looking for what topics would you like to hear about at the summit. So we want you to help us with some of the programming. If there's a particular topic that you think we should address, let us know. And we have about 50 people who are already signed up for the summit. So, you know, we have to cut it off eventually if we get, you know, too full. We only have space to accommodate so many people. So we encourage you to sign up sooner rather than later so that you can make sure you do get a registration slot. Because if we have to reach that cutoff, then, you know, we'd hate to have to turn people away, but we only have so much space. Okay, so that is that next one. And then let me go to the next screen here. 1 second. Okay. At the Tenant Summit, we are also going to be showing our OTA Tenant of the Year. And we did this last year. Miss Beatrice Evans, or Miss B, was our Tenant of the Year. And she's so active in her community. She still is very active with her tenant association and with the citywide tenant association that she's trying to start around the city. But we are looking for our 2026 Tenant of the Year this year, who we will be you know, honoring at our Tenant Summit on September 19th. So if you know a tenant in your community who works really hard and has accomplished something great this year. Or if it's yourself, you can nominate yourself if you want to, if you think that you should be the tenant of the year too. So we have this submission form. Criteria are that you must be a tenant. You must be available to attend the Tenant Summit on September 19th. And we ask for a quick little write-up about, why you think you deserve or this person deserves to be the tenant of the year. So we're looking for nominees. We already have a couple of nominees out there, but we're looking for as many as possible so that we can make a decision about who we think deserves this opportunity. So please get your nominees in soon. And again, I'll be dropping the link for that at the end of my presentation as well. The next thing I have is the Tenant Summit Volunteer Interest Forum. We had some wonderful volunteers last year. I know some of them are on this call right now, so thank you, volunteers. We appreciate everything you did for us. And again, we're looking for more volunteers for this coming Tenant Summit as well. You get sort of all access, I guess. You get to be involved in the process, and you get a free t-shirt, and you get to, chat with the OTA staff and really help be a part of making this event so successful. So if you're interested in volunteering, again, we have this form where you can sign up to do so, and we really hope that you all will be able to attend. And then the last thing that I wanted to show on my end is some upcoming trainings that we have. So for those of you who don't know, we have a renters' rights training once a month, every month. It's almost always the third Thursday of the month, unless that falls on a holiday. So we have this every month all year round. And if you think you would like a refresher on renters' rights, please get in touch with us to schedule this class. If you would like your own individual class for a group of tenants, we're happy to do that for you as well. We can sign up for an ad hoc type of class at a date and time that you're available. So just let us know. We also have eviction prevention trainings. We're doing 4 of those a year. So the next one is July 15th. And then we also have housing code violation training. So there's one coming up in August as well. And tenant detective trainings, the next one will be in September. This training talks about what kind of online databases a tenant can use to research their landlord, the same way that a landlord might research a tenant before they move in. So we really encourage everybody to get in touch with us about signing up for these trainings. You can do it online on our website or just email me, either way. And yeah, we really hope to keep tenants engaged and excited about all the things that are going on in the tenant community. The last thing that I wanted to talk about, I don't have something cool to show on the screen about this yet, but as part of our summit, we are looking for sort of testimonials from tenants to talk about the OTA and their experience with us. We're celebrating 20 years this year, which is a huge deal. And so for that, we wanted to make a sort of anniversary video, I guess, with testimonies from tenants and interviews from tenants over the course of the past 20 years. So if you're interested in lending us a little video and having us record a little video of you, please get in touch with us. We would love to do that. We could either, meet with you to do this video, or if you want to just send us a clip via text of you, recording yourself, that's fine too. So yeah, please get in touch with us for any and all of these activities. And again, I'm going to drop the links for them in the chat. And that is, I think, all I've got to say. I see somebody asked in the chat, do you have a flyer that lists all the classes? Yes, I can send you a flyer that sort of lists everything comprehensively for the rest of the year. And that said, are there any just general questions about education outreach activities or the Tenant Summit before we get to the real, meat of it, which is like hearing from tenants about what's going on in your community? Is there a directory of associations? We don't have a directory of tenant associations because a lot of them are a little bit hesitant about having that information like publicly accessible. Sometimes they don't want landlords to know, who exactly, is in charge of which one. But we do kind of like have tenant associations who meet once a quarter and just chat about what's going on. So I'm happy to add you to that group if you leave your contact information, and we can get you in there. We call it our Tenant Association Peer Mentorship Group. And I see a question from Linda Lee, so I'm gonna unmute you. Can I do that? I think you can unmute yourself, Miss Lee.
Can you hear me?
Yes, we can.
Okay, so I'm over here at Edgewood, and this place is turning into a zoo, and it's about two of us trying to take it on. Anyway, we got a letter the other day changing our designation from a senior building, that we won't be a senior building anymore. And I don't know. Sheila's checking on it, but I don't know. It's just, and the issues around our management, they're like totally antisocial. So is there going to be any help for stuff like that? I understand you're talking about issues with management, and
Yes, ma'am, there will be assistance. What I would recommend you do is to call us during the working week and give us as much information about this situation as possible, and we will follow up. We will follow up immediately.
okay, thank you.
Yes, ma'am.
And happy to take other questions from other tenants. If you could just raise your hand or put it in the chat. I do see a couple of questions already in the chat, so I'll start there. The next one is there a best practices document for tenant associations, including sample documents? I'm so glad you asked that. We have that as part of our education and outreach materials. So we actually, it's literally called best practices. We have a tenant association class that talks about, what are the best practices for the treasurer when they're setting up a bank account, or what are the best practices for what to put in your bylaws? How do you use Robert's Rules of Order and parliamentary procedure to execute your meeting? So yes, we are happy to provide that training, and we have sample documents, like a sample template for bylaws and articles of incorporation, and all of that good stuff. So yeah, if you get in touch with me, I put my email in the chat. We're happy to set up a class for you in the near future. I see also in the chat a suggestion. It says recommend legislation making it mandatory for property management team members to have 3 to 5 years of DC property management or go through DHCD property management training program. That's a great suggestion, and I hope our policy team are taking notes on that. I do know that there is a property management exam that exists in DC, but there are not continuing training requirements or a certain number of education requirements before the exam is taken. So I think our policy team is looking into what is required and then what should be required, right? I don't know if Joel, if you had any additional comments on that.
Well, what comes to mind, Johanna, I'm not sure if now is the time, but we had been involved and engaged with the Real Estate Commission towards exactly that end, with certification based on knowledge of the law, et cetera. Joey was sort of our lead delegate to the commission at that time. I don't know if our chief tenant advocate or if Joey wants to make a comment about that, or if that kind of answers the question.
Well, I'll make a comment. I mean, this is Johanna Shreve. I think that property managers should be engaged in the Institute for Real Estate Management, which is the National Training Association for Property Management nationwide. There should be a code of ethics for property managers. And I'm certain that property managers can also get that from the National Multifamily Association. They have a lot of information. And of course, what Joel is alluding to about us, we are meeting tomorrow with the coalition to talk about this very subject on property management, because we get a lot of complaints about property managers in the district. And there's no guidance on a regulatory level or a statutory level with respects to the city, where other jurisdictions have more actively professional property management activities going on. And I think the city needs the same thing. As well as regulations and statutes change, property managers should be required to participate in training and be recertified. if property managers are dealing with subsidized housing, they should know the project-based voucher, all of the Section 8 programs, as well as the other programs that govern the financing of some of the deals that have been done in the city. So if you're in a low-income housing tax credit property, you should know Section 42 code. So, I mean, I think that there's a lot of requirements that we see property managers not adhering to, and or professional conduct that impacts negatively on the tenant community.
Any additional comments or questions? Our chat is open. Or of course you can just raise your hand too, and I'm happy to, unmute you. Oh, I see a question in the chat which says how to handle a resident who consistently violates the lease, yet is still allowed to live in the building. They've learned how to avoid the system when taken to court, and building management appears to have stopped addressing them. They're selling items on the side of the building and panhandling, smoking marijuana that seeps into the hallway. They have a dog that barks a lot, and the smell of dog poop seeps into the hallway.
So can you hear me?
Yes.
Hi, this is Janice Farabee. I am the Tenant Association President at the Cambridge Apartments. And I want to thank you all, everybody there, from Ms. Shreve to Joel Cohn, everyone. So I'll do a testimonial, but tenants, and they are it is a voucher tenant, and I don't care how you pay your rent, but if you cannot abide by the rules of the community, then you don't belong in the building. And she's been here for 4 years. First day that she came in the building, she put her hands on the community manager. She has, there have been things, been to court, been to jail, run through the lobby naked, all sorts of stuff. But we cannot get her out of the building. And again, goes to court, doesn't come with an attorney, so they have to continue. She has recently harassed me, and there are just she's sexually harassed somebody else in the building who would not say anything. This continues, panhandles now in front of Streets Market, sells stuff on the side of the building, no permit, but and cussed me out one day when I came and took pictures of what she was, so what do we do? And that could be another conversation at another time, but I just need to find out what to do. Just to terrorize, she's terrorizing the building and continues to be here. And it's go ahead.
Nicole, do you want me to, I can do a brief comment. There are contractual obligations, explicit and implicit, in a rental lease. Landlords and tenants are co-equal, parties to the agreements. One is that there is a general obligation that landlords have to protect or at least not to upset the tenant's right to quiet enjoyment of the premises, of their unit and the common areas. If a fellow tenant is creating a nuisance, that could, it's really a question of severity, duration, and other factors, but there could be, and I'm not saying it's an easy legal claim, but there is an obligation, and it is something that first and foremost, the affected tenant or tenants should absolutely bring the landlord's attention to it. And if it's particularly, as it becomes a more severe problem, establish and document sort of a pattern of not only the behavior or the nuisance being created by a fellow tenant, but if it's the case, the unresponsiveness and failure of the landlord to act. Come into OTA, talk to an OTA attorney advisor, and see what could be done in terms of some sort of legal remedy. I want to emphasize it's not it's not necessarily an easy issue to solve. I don't know if Kevin DeGood is still on the line, but I know this has been an issue that Councilmember Fruman in particular has been very, very focused on and has proposed legislation. And so if Kevin is on and he wants to comment on anything legislatively that maybe was considered, can still be considered, raised again, that would be great. But I don't see him on. So I'll leave it at that. But John, it's great to hear your voice. Thanks for coming.
Absolutely. Thank you. And I will submit something because you all have been extremely helpful over the years to me. I've referred folks to you all, and I just really appreciate all that you do. So thank you.
Absolutely.
Yes, Janice, please call us about this. Your property is not the only one that has experienced this situation, and I think it would be a novelty to see how the tenant association could be effective themselves in pursuing this. Yes.
Yeah, I will. Thank you. And thank you for everything. Bye-bye.
All right.
I also see that Mike R has his hand raised, so go ahead, Mike. I think you can unmute yourself.
There we go. Hi. Is this where we should be discussing an issue? Because I just wanted to add a few points to that as well. The problem with the quiet enjoyment part is no matter what anybody's discriminated against in the world, they can go to court and sue. If you fire me because I'm gay or a woman or a person of color. But if you violate my right to quiet enjoyment, the law requires me to convince the landlord to fight for my rights. That should be a non-starter. That's number one. In my building, it was 7 years of hell. And the only way we got rid of this person to kick management along, who they make so much money off of this Section 8 program, it's in their interest to keep people in those apartments. We, at tenant expense, had to get a TRO, temporary restraining order, against this woman who was there on a voucher. What is astonishing to me is the District of Columbia can hand you a $2,500 voucher and you do not have to talk to a mental health professional. You can literally slam the door and you're given tens of thousands of dollars over years, and no one is allowed to have you say, you know what, if you're going to get this voucher from the city, which we're not even going to try to let you think you're going anywhere. We're going to call it a permanent voucher, right? We're not even going to encourage growth, and can't require that they talk to a social worker 4 times a year. This is insanity. This is literally insanity. And no one cares about doing anything. And I know OTA's hands are tied because you can't work on tenant v. tenant issues, right? You can't step in when a tenant's fighting a tenant. So you have us suing with the people across the alley to control this person. Something has to happen. That Northwest DC is being destroyed. When I heard 3 years, I said, wait for my story. 7 years of hell. We were going to get to the point of making her life more miserable than ours. And so I just want to put this out there. And we met with every city council member, policy people. They all say they care, but they have no way, there's no mechanism for me to sue that woman destroying my quiet enjoyment. I wish the Attorney General's people were here because that's something they should be addressing.
Mike, let me ask, this is Joel. Let me ask you, do you think any of the behavioral issues involved, violence, illegal acts? I think, assault, certainly certain categories of assault, anything like that?
Oh, Judge Meek gave a restraining order because this woman went off in court. I mean, there was yelling, screaming, pounding on the association president. We used to flip, a couple of us, 3 of us. She was like, I'm out of here. And then the association's paying for temporary restraining orders. So no, she had a rope hanging off of her balcony to escape from the 7th floor, telling people she was an FBI agent. I mean, literally, this is who, and never had to see a social worker. And and lived in a studio for 1900, moved to a 1 bedroom for 2600. You're not allowed to judge. That's her voucher. But then she goes online and begs for money for panties, food, personal hygiene products. When someone's handed a studio apartment in a doorman building with a swimming pool, and they're not required to see a social worker ever, and then can tell the building, this studio is not big enough for me, I want a 1 bedroom with a balcony, and then has to go online and beg for panties, women's sanitation products, perfume, food. The system isn't working, and it's not me. I know there's a lot of people on this call, and some of them feel they can't speak up. That isn't my nature. That's all.
So-
It's a joke. The system is right now, and I just want to add something. Last thing, it's not OTA. You guys are great. I know that I have heard from so many people the help you give, and I just want to acknowledge that my frustration is not with the people who are working on behalf of OTA and you guys, and that's important. It's policymakers. We're all
Well, I was gonna-
suffering from the policy.
Mark, I was going to say thank you for that. And I was about to say you're raising some very serious and strong policy issues, some of which our chief tenant advocate has talked to the mayor's office about, et cetera. I do want to mention you may know about, and you may have considered the provision in the new Rental Act, which does provide. The reason I asked about illegal acts and violence, et cetera, is that the Rental Act includes a provision for expedited eviction under the violation of a public safety standard.
If the landlord wants the eviction, not if the 275 people whose lives are being made miserable. We
Right.
have to count on a landlord, and the city has set up a system, man, give me an apartment building. They have private equity coming in. I gave this personally to Council Robert White staffer. He was actually at the meeting. I handed him the private equity letter, really bragging about how here's how we can squeeze more money out of the system from you. Here's how you can get 90 extra days when someone is thrown out of the building. 90 days of increased rent. Those rent controlled apartments, they're no longer rent controlled on Section 8. I mean, the whole thing is a joke for the landlords. It's a cash infusion to the landlords. Tenants be damned. That's where we are. Sorry, you asked.
No, I did ask. I'll just one shoot a drop there. I'll say these cases are definitely tough, and I'm not trying to say there's an easy answer by any means. I do think, legally speaking, in terms of a legal action and legal obligation and actionable right under the lease, the landlord really does have a legal standard of taking reasonable action, which, if the fellow tenant's behavior is so severe and so bad, it could mean that the landlord should be doing what is necessary.
They're afraid of being sued.
Using an eviction
They're
tool.
afraid of being sued. That's what happens. There's a lawsuit turnaround. You're discriminating. I know it. I know the building. I mean, this is what happens.
Can I
I
just,
hear you.
I'll be in touch with you, Joel. I'll be in touch.
Okay, good.
I just wanted to say something also, and I will be in touch if there's an opportunity for those of us who are having this issue to sit down. I really would like to do that. I saw a note about, that voucher holders are also tenants. I'm a trained social worker and have 35 years in recovery from drug and alcohol abuse and work as a peer support specialist. The comment that I made before, and it's what I made to policyholders, it's not about being a voucher resident. There are voucher holders in buildings all over the place. You don't even know who they are. It's about how you act. So the gentleman that was just speaking, I don't care who you are, how you pay your rent. If a renter like me, if I were doing all this stuff, I would be evicted immediately. What the issue is that individuals are not ready for independent living, and that is the fault of the government and the DBH and all of those folks who are supposed to be handling when you give out vouchers. Yes, they are supposed to, but they don't get the support that they are entitled to. And they come into apartments where they're not ready. And so if you're a regular tenant and you're not, and you can get evicted, but it's shortchanging, and it says a whole lot about how we feel about, our residents who need assistance. We are releasing these individuals without the support that they do need, and they then get this bad, they become bad actors because they do need help, and they need they need information, they do need all this stuff. But that's part of the problem I have, that they are not getting the with what comes with the voucher, or what's supposed to come with the voucher. They're supposed to be getting social workers, case managers, who are supposed to be working with them to get them prepared. That's not happening. So again, I just wanted to say, for me, it's not about how you pay your rent. So the stereotype and all that stuff, it's if you cannot conduct yourself and in the community that you're living in, then you do not belong in that community. I don't care if you make $1 million a year or $1. So it's not about being a voucher. Unfortunately, it happens to be a lot of those individuals, but it's because they are not getting the support that they need, the social services that they need to make them ready for independent living, because everyone deserves and is entitled. But when the government does not do what they're supposed to do, this is what happens. And I am more than happy to talk about, and I even presented something to Wayne Turnage around, a project, a program for what needs to happen, but they're not doing it. So they're not doing it, and individuals are causing havoc, wreaking havoc. And so I'm just going to stop there. But it's not about being a voucher resident. It's about being ready for independent living, period.
Thanks.
Very
Yeah, and
well
I
said,
want to
both
give
Mark
other
and Jen.
people, sorry, I want to give other people a chance too, to say what they wanted to say as well. So I see in the chat, this is sort of relevant to this conversation too, is Mark said there's a deficit in the depth of the data which is available to those who do policy or advocacy work as it relates to demographic information for DC tenants. And it's hard to make any sort of arguments without this data. So how can we build this data into DC programs, or get this data? I think that's an interesting question. And I maybe that's a question for policy or council to come up with a way to actually sort of like quantify and have some data on what is actually happening here.
I'll just say, very well said, both Janice and Mark. So I hope that the engagement continues on that issue. And certainly, it's difficult. If it was easy, there have been policy proposals involving government agencies proposed at the council, the public safety eviction standard. But if it was easy, the problem would have been solved. So we're looking forward to continuing that dialogue. And thanks for those comments.
And then I also see Mr. Main asked if there's a status update on the DC Tenant Bill of Rights.
Yes. If Joey, I'll speak to that unless you care to. Do you want to say a word about that, Joey?
Yeah, go for it. If I'll jump in if there's something to add.
Okay. Well, simply that we are kind of seeing the finish line, or the home stretch. We have solicited over, external comments on a draft Bill of Rights. We had to pause the project because of the Rental Act, which had a huge, as everybody knows, a huge impact on tenant rights in two areas: evictions and TOPA. We have picked that ball back up since the Rental Act took effect at the end of last year, literally December 31st. And we have talked to both tenant advocates and housing provider representatives, gotten their feedback, and it's now in an internal review process. We expect to end to have publication. I think our time frame, remains what it was, which is by the end of the fiscal year. Joey, I think it's fiscal year, not calendar year. I just want to double check that. Is that
Yes,
right?
exactly. That's right.
So that means that we're aiming for publication of the revised tenant bill of rights by September 30th, and publication does not mean it's being commented on and there's a whole process. Publication actually triggers the requirement that landlords use the newly revised tenant bill of rights and attach that to leases and show it to prospective tenants as well.
Awesome.
So I hope that answers
Thank
that
you.
question.
Yeah.
Yeah.
And then I think the next hand up was Rosalind. So I think you can go ahead and unmute yourself.
Yes, good afternoon. Can you hear me?
Yes.
Yes, I just wanted to speak to the residents or the tenants who are having problems with disgruntled and unruly residents in their building. We had a problem here for about 15 years or more. And just recently, that resident was evicted. But may I suggest you videotape, take photographs, and document. Don't just send this information to the management company, but the owners need to know as well. And trust me, they will do something. We had a person that did everything but kill somebody, okay? And they may have even done that. We just didn't know about it. But they did finally get them out of here. But you have to document, you have to photograph, you have to videotape some of the nonsense that goes on and get it to the right people. Okay? Thank you very much.
Bingo. And I'll just note there, Nicole, that that in answering Mark's question, I totally understand where Mark is coming from. But it is something that is a tenant right. Tenants have rights under the lease, believe it or not. And that should be understood. And the more you document any kind of breach of the lease by the landlord, the stronger a legal claim you're going to have, and the more there is to talk about in terms of possible redress when you come in and talk to a OTA attorney. So that's an excellent point. Thank you for emphasizing that.
Thank
And
you.
then I think Miss Melinda was next.
Hey, Nicole and OTA team. Really appreciate these events that you all put on. You are one of the best city resources that we've got. So thank you. I'm the president over the Dorchester Tenant Association. Most of you have probably heard about the incident involving our neighbor and an elevator. We are very excited that replacement is beginning on that elevator literally today. But as we've been working on this issue, obviously a lot of stuff has come up, and we've heard stories like the ones like we've been talking about in the chat with like buildings having all of their elevators out of service, and landlords letting it go for months, and obviously that being a huge issue for tenants in wheelchairs. I'm curious, one of the things I've heard from folks is a lack of elevator specialists in the country and just providers. I'm curious, like OTA team, if you all have any thoughts or insight on that. It seems like it is poised to be a big issue over the next decade in DC, with a lot of elevators that are just falling apart and need to be replaced, and not having the resources to do that.
We have an ongoing dialogue. In fact, there's a direct line between Director Shreve and DOB on the issue of elevators, and it is highly problematic because of obsolescence. The difficulty of getting parts sometimes is far away as far as you can think. And it is, if a housing provider has to wait apart, they are not being derelict. They're not acting in bad faith. It's just the reality. So that's not the whole problem. Certainly, of course, there is dereliction, a lot of dereliction, and valid complaints about the housing provider with regard to elevator disrepair. I don't have much to say about that beyond that, other than there's ongoing dialogue. We dialogue with a lot of different agencies on a lot of issues. This is, I think, Director Shreve, I think, would agree. It's a good conversation, and the issues are being brought up. The problem for the agency in terms of the other agency in terms of enforcement, et cetera. So I think so long as there's a good dialogue, there's hope that, it's not an easy fix, but there's hope that we can aim towards some kind of improvement, if not resolution.
This is Johanna Shreve, in answer to the Tenant Association president at the Dorchester. We're very sensitive to the issue of elevators, as you are well aware, and I certainly would be happy to pose a question to Brian Hanlon, director, and Keith Parsons, strategic commander over there, to find out if, in fact, they have done an analysis of what the status of the air conditioning community is. The law says every 6 months they're supposed to inspect them. We know that elevator inspectors are hard to come by, as Joel has indicated. We know that there are a lot of old elevators in the city, which results in parts being needed. And so there does need to be some sort of strategic process put in place that addresses this issue, because when we have properties go down for not having elevators working, it is unacceptable for us to hear that DOB has reported that as long as one elevator is working, everything's fine. That's horse manure. That's not true. It's not the law. So we need to get that straight and get the right codes in place to address this issue. But it is a very troubling issue to us, particularly when most housing providers fail to put individuals who are handicapped or elderly on first and second floors of buildings. So, when we see that tenants have been subjected to having the fire department or other people having to bring them downstairs for them to attend doctor's appointments or whatever the like may be, we know that there are issues that do need to be addressed, because we're living at a different time. So we'll put it on our list, and we'll follow back up with you. Certainly, we'll make sure that it's something that we bring up at the summit, which will happen in September, which would be the next quarter, to let you know what we found out about it. And we'll have somebody from DOB there to address this issue, because it's a big one. It's one that we know the government needs to come together and figure out what's the plan.
Amazing. Thank you for that response. It was very comprehensive. I really appreciate it. And I will say, Keith Parsons actually came for a sit-down meeting with us. That was somewhat productive. But definitely one of our takeaways from that meeting is, in addition to the age of the elevators,
Right.
there's also some stuff in the safety code that continues to be an ongoing issue for our tenants. It is not just our neighbor who lost her arm who had an issue with the doors closing. Our neighbors in wheelchairs routinely have doors close on them.
Yes,
And
yes.
Keith was like, that's all up to code. Like, it's supposed to automatically close after a certain number of attempts, and doors that close within 30 seconds are perfectly acceptable, even though, we have small elevators that are hard with people with wheelchairs to get into. So we would definitely love to work with OTA and DOB and the city council to change the code so that they're more inclusive, because it's just definitely not working for our neighbors who use wheelchairs.
Yeah, we definitely need to put a big eye on this, and whoever's coming in the to govern the government of the District of Columbia going forward will have a few things on their list, and we certainly will make those. I will make sure that I make those available to the next mayor, so that they're aware that this is an issue that should not be ignored.
Yeah, and
Thank
in
you.
sorry, go ahead. And by the way, Melinda, I'm so glad to hear that literally today they are now actually fixing the elevator. I think this was what, November when it happened, October. So I know it's been September.
Late
Yeah.
September.
Yeah, it's a long time.
And I will say on the things take too long. In their notice to tenants, they noted that they had started the process for replacing the elevators in March of 2025.
Yeah.
And so it took 50. And so I'm worried about how long it would have taken if they hadn't started that process 6 months before the accident.
Yeah.
But thank you again. Appreciate the response, and look forward to working together to address this issue across the city.
Okay, wonderful.
And along the same lines, there's another sort of comment in the chat, or a question, I guess, from Dennis that's, what if the management fixes the elevator and then it breaks the next week, and then they fix it again and then it breaks a week later? How do we address that issue as well, which I think goes to the same kind of general overarching question. So yeah, I think answers on these things are things that we're really hearing tenants want to talk about. So thank you everybody for that.
But we don't want to go back. Let me just say this, my pet peeve, replacement reserves. This is one of the areas where housing providers, owners, need to do replacement reserve analysis so that they're putting money aside to be able to address these kinds of issues, particularly when they purchase existing buildings that are aged. And if we get into what we will be doing at the OTA before the end of the year, is putting together the building closure analysis. We are looking at buildings that were built back to as far as 1920. So we have properties in the city that are very, very aged with very, very aged equipment. And you can't run the train without fixing the rails. So you've got to keep things up to speed. You have to have a preventative maintenance schedule. And it's telling us that that's not happening, particularly when we've had in FY25 alone, we had 169 buildings closed. We're going to have a similar number in FY26. It means that preventative maintenance is a major issue for the city to address going forward. So, these are our hot topics and things that we want to keep people on their toes to let them know that we are thinking about them every day and recognize that some of them live in precarious housing constructed properties that, not for their fault of their own, but when a building is 100 years old or 80 years old, it needs to have a lifeline thrown to it.
Absolutely. Yeah. And as we're kind of closing out here, as we're approaching 3, I wanted to see if there are any last questions from anybody, or suggested topics other than what we've already talked about for our summit. We'd love to hear from you all before we close out. Dennis, go ahead. I see your hand up. Oh, can you unmute? It doesn't have a way for me to unmute you.
Tell them to write in the chat.
Okay, I see
There we
that
go.
Microsoft requires Control-Shift-M on my computer. I recently came into the following situation. After a few years of posting flyers all around the building to get tenants' attention, which I always follow up by taking every single flyer down extremely quickly. Recently, we came into the problem where they took our flyers down. And ironically, it was a flyer that a new tenant new member of the Tenants Association, said that she wanted to create a WhatsApp community. And the flyer was to create the WhatsApp community channel. They took the flyers down. So right now where we got to is a spot where they say, well, you're allowed to put them on the bulletin board. And I read the law. I read the statutory code with respect to, you're allowed to distribute in the lobby. You're allowed to put them under the doors. You're allowed to put them on the bulletin board. Well, the bulletin board is ignored by everyone in the building, pretty much, about 90% in the building. And there's no space on it. And the stuff that's on it is old. It's about, there's not even 6 inches to spare on it. So they said, give us your flyer in advance. We'll review it. And if we approve it, then you could put it up around the building. I put them up in great quantity because people are entering the building. They're looking at their phone. They're talking to someone. They had a bad day. They're carrying something. And they're not looking at the flyer that I think happens to be important about tomorrow's night's meeting. So I put up flyers all around the building. And it gets people's attention. So now they are reviewing and approving, and they haven't said no completely. There was a problem, but generally speaking, that's what we have to do to get a flyer up. I think it's un-American. I think that the code is insufficient. Maybe in good faith it's sufficient, but without good faith, it is not sufficient. I don't want, for every X number of tenants, they should be able to put up 1.3 flyers. I don't know exactly what the solution is. It's really, because in my case, I'll tell you that we have 275 units. I put up 50 flyers because we've got 9 floors and it's horizontally, our building, the Argonne, is a very, very large physical footprint horizontally. 50 flyers, actually, you could put up 100 and still not saturate the building, in all honesty. So I don't know if it's a matter of, one every floor. I mean, even that's not frankly good enough, but I don't want to try to do it off the top of my head. I haven't yet come up with language, but something needs to be done, in my opinion, because the way I see it is, if a building doesn't have elevators working for seniors with the firefighters, I mean, that's absolutely nuts. If there is a time when we again there's a time again that my building does not have heat, and I'm president of these Tenants Association, when we don't have heat, and the flyer that we want to put up is come to the meeting to discuss what to do about no heat, and they take it down, I want that as the headline in the newspaper. What I really want is to prevent that from happening, though. And so far, they're mostly cooperative. So I just put it out there to see if there's something that can be done in order, which I think has to be through administrative code. Because and someone asked, is it interfering with tenant organizing to have them approve the flyer? They're not saying they have to review the flyer. They're saying, if we want to post the flyer beyond where the law says we have the right to post it to, then they'll gladly look at it and consider reviewing it.
But then, so just FYI, the 10 revisions to the 20-year-old OTA is 20 years old. So is tenant right to organize law. One of our priorities for the coming year is to revisit it, because we think that law is vastly underutilized. And there are a couple of reasons in terms of deficiencies in the statute, including financial remedies, penalties, enforcement. I'm curious, as you say, you have a statutory right to place flyers under doors. What is the landlord saying about that? They will do it, but they have to review it first? What?
No. It has nothing to do with that. So first, here, my view about distributing flyers under doors is this. One, it's extremely effective. It's extremely time consuming, and it can be annoying to the recipient. And I have to respect that. As an organizer, I know that some tenant, hey, enough with the flyers. I don't want to see another flyer. Or they'll be getting other flyers, and then it proliferates. And that's also another reason why I think it demands to be respectful to the tenant to not flyer under the doors frequently. So this is what they did say, the landlord, about that. They said, you can distribute these under the doors. And I said, that's not for you to say. You have no standing to review and to consider and to tell me whether or not we can push that under the door. And the reason I say that is, are they going, is that I'm suggesting that they might not like another flyer, and they'll say, well, you can't put this one under the door. They have no standing. They have no say whatsoever on that. So I saw some in the chat say, you know, we could put door hangers up on the doorknobs of the doors. We have 275 households here. We have, and yes, it's effective, whether it's on the door or under the door, but it is time intensive. And having a flyer in front of the elevators, having a flyer in the elevators, having a flyer next to the laundry room, and having a flyer by the front entrance, that is effective. It is great reminders. And that's where they said, you don't have a right to do that. And they're right. We don't, technically. And someone said you could interpret the law broadly. I'd love to know if the law can be interpreted broadly to protect this right, protect this as a right.
So
I would suggest this. I think you would please be a part of the conversation when OTA proposes to the council, and I see Sean is still on. Thank you, Sean. Revisions to the Tenant Right to Organize Act. It's dubious because the explicit right is common areas, including lobby, as you say, under the doors, and then posting information on all building bulletin boards. So you're right when you say that that specific issue with your landlord, you know, might call for some sort of revision to that provision. So we're concerned about, you know, I guess broader enforcement and penalty, you know, problems or shortcomings with the law. But if you would, I really appreciate all the comments today that you'll be in folks will be in touch about these issues. And Dennis, if you would be in touch with myself and our legislative counsel, Joey Trimboli. I'm at Joel, JOEL.Cohen, COH @DC.gov. And I'd love to be in touch about that.
And Joel, you and a few other attorneys at the office, we've spoken before. You've been of great help, so thank you.
Oh, terrific. Thank you.
And I want to thank you for bringing that up too, because that is actually one of the topics we were considering discussing at the summit and having maybe a panel to talk about this, because it's not just your building that's facing it, clearly from the chat and clearly from interactions we've had at E&O when we go out to buildings. And I've personally had this happen to me where the management has restricted the tenant's right to organize, and I was a tenant organizer there, and you know, things happen. So yeah, so we think it's a topic that's worthy of discussion at the summit. So I think that's part of our plans here. So anyone who would like to be involved in that discussion and be on a panel or attend it, get in touch with us because we'd love to talk to you more about it. But with all of that said, I think it's about time to wrap up. I want to thank everybody so much for attending and for letting us hear from you. You all have really insightful comments, and it's really good to hear about what's going on in the city, because I think every issue we talked about isn't affecting just one building. It's affecting a lot of buildings. It's affecting multitudes of tenants, right? So, you know, having these discussions where we all talk together about it is really productive, I think. Ms. Shreve, Director Shreve, did you want to have any closing remarks?
No, ma'am.
All right.
But I do thank all of the tenants for participating. We really appreciate you being on the stakeholders meeting. We hold these meetings every quarter for your benefit, to provide you with information as best we can and to hear from you. It's very important that we know what's happening in your community and what's happening on that day in the neighborhood.
All right. Well, thank you, everyone. This meeting was recorded, so I will, in the coming days, put it on probably YouTube and then link it on our website and send out the link to everybody. So thank you and stay in touch and have a great holiday next week. Bye, everyone.